This is UT System Administration Health Insurance Portability and Accountability Act training. This training is for contractors, vendors, and other third parties of the University of Texas System Administration. As a business associate for the University of Texas System, you are required under HIPAA to successfully complete training related to your responsibilities in handling RPHI. This training generally covers HIPAA at a high level and is meant to provide education and understanding of the legal requirements related to compliance with HIPAA and the HITECH Act and the Texas Medical Records Act, Chapter 181 of the Texas Health and Safety Code. Further understanding and application of the above referenced laws should be addressed with your attorney or compliance officer. HIPAA, the Health Insurance Portability and Accountability Act, was passed to create national standards to protect individuals' medical records and other personal health information, provide patients' rights over their information, and protect health insurance coverage for workers and their families when they change or lose jobs. HIPAA is composed of the privacy rule and the security rule, which address each component of compliance when creating, accepting, transmitting, or handling health records. In this course, you will learn how HIPAA applies to the University of Texas System Administration and how to comply with HIPAA. This course is divided into 6 parts covering the major components of HIPAA. Part 1, what is HIPAA? Part 2, using and disclosing PHI. Part 3, safeguarding PHI. Part 4, individuals' rights of access to PHI. Part 5, the Texas Medical Records Privacy Act. And Part 6, summary and policy acceptance. Part 1, what is HIPAA? HIPAA is a federal law composed of privacy rule standards and security rule standards created to address the use and disclosure of individuals' health information, called Protected Health Information, or PHI, by organizations subject to the privacy rule, called covered entities, as well as standards for individuals' privacy rights to understand and control how their health information is used. This training will focus on the privacy and security rule. The HITECH Act was created to strengthen the privacy and security protections under the original version of HIPAA with the rise of electronic health records in the medical industry. The HITECH Act strengthens elements of the privacy rule, directs HHS to conduct regular audits to ensure compliance, authorizes states' attorneys general to bring actions under HIPAA, and raises the penalties for noncompliance. Who must comply with HIPAA? The HIPAA privacy rule applies to health plans, healthcare clearinghouses, and any healthcare provider who transmits health information in electronic form in connection with transactions for which the HHS has adopted standards under HIPAA. Here at UT System, the Office of Employee Benefits, or OEB, administers the health plans for all system employees. OEB is UT System's covered entity and therefore is required to comply with HIPAA. Under HIPAA, covered entities must safeguard individuals' protected health information when they store or transmit it, request, use, or disclose PHI only as permitted by HIPAA, provide individuals certain rights with respect to the protected health information as required by HIPAA, provide a privacy notice that explains individuals' rights under HIPAA, ensure group health plan documents comply with HIPAA if applicable, create HIPAA privacy and security policies and procedures, and appoint a privacy officer and security officer. In September 1977, the Texas legislature passed a law authorizing the establishment of a uniform group insurance program for the UT system. The program began on September 1, 1978. Today, more than 250,000 employees, retired employees, and dependents are covered. The UT System Board of Regents created the Office of Employee Benefits to administer the employee group insurance program for all UT System employees and retired employees. OEB performs functions as a covered entity under HIPAA when it acts administratively on behalf of the self-funded health plans that it offers to members. OEB's HIPAA Policy Manual can be found in HOP 4.1.4. Who else has to comply with HIPAA? Business associates are individuals or organizations other than a member of a covered entity's workforce that perform certain functions or activities on behalf of or provide certain services to a covered entity that involve the use or disclosure of individually identifiable health information. The second type of organization that must comply, as mentioned in the previous slide, are business associates. Examples of functions performed by business associates include claims processing, pharmacy benefits management, management consulting, accounting services, administrative services, actuarial services, legal services, and billing. Prior to sharing PHI with a business associate, a business associate agreement or BAA must be signed. The BAA requires compliance with the HIPAA privacy and security rule requirements. No PHI may be released to any business associate who has not signed this contract. Business associates must comply with both the terms of the business associate agreement and directly with HIPAA rules. They are subject to periodic compliance audits and are subject to direct regulatory actions and penalties. Information about UT System Administration's healthcare component can be found online at the following link. The UT System Administration is subject to HIPAA and is required to train employees with access to PHI, develop a complaint process and sanctions for violations, develop a contingency plan for emergencies, establish ePHI access controls and security mechanisms, and enter into a BAA with vendors. What information is protected? PHI is any information that can be used to identify an individual, living or deceased, that relates to the individual's past, present, or future physical or mental health or condition, including healthcare services provided and payment for those services. PHI can be found in any form or media, whether electronic, paper, or verbal. What information is protected? Components of protected health information are names, postal address information, social security numbers, medical record numbers, health plan beneficiary numbers, financial account information, biometric identifiers including finger and voice prints, and full face photographic images and any comparable images. HIPAA requires covered entities to appoint a privacy officer to train or arrange for the training of all staff and any other workforce members of the offices within the UT System healthcare component regarding systems privacy policies and procedures, facilitate and cooperate with investigations initiated by the Secretary of the Department of Health and Human Services, safeguard PHI through the creation and implementation of policies. HIPAA requires the privacy officer to investigate incidents of inappropriate use of PHI or access to PHI, report confirmed breaches of PHI to the Office for Civil Rights within the HHS, respond to patient inquiries about access to PHI, and provide notification to affected individuals in the event of a confirmed breach. If you suspect a HIPAA violation has occurred within UT System or within your scope of providing services to UT System, report this immediately to the UT System Privacy Officer and your immediate supervisor. Part 2. Using and disclosing PHI. The HIPAA privacy rule mandates that hospitals, health plans, and other covered entities keep protected health information confidential and use it only as allowed by HIPAA. Use or disclosure of PHI may not occur unless a valid authorization exists or an exception in the privacy rules permits the release without an authorization. That authorization must be written, not oral, and may be submitted via paper form, fax, or electronic media. A valid authorization will describe the PHI to be disclosed, who may receive or use the PHI, who may release the PHI, an expiration date or event, a statement of the individual's right to revoke the authorization, and a description of how to do so. a statement of the individual's right to refuse to sign the authorization, and the purpose of the use or disclosure. Authorization is not always required. For example, it is not required when disclosing the individual's own health information to him or her, disclosing records for purposes of HIPAA enforcement, conducting public health and safety disclosures required by law, and accessing, using, and disclosing PHI as necessary for treatment, payment, and healthcare operations. Questions regarding authorization to release PHI must be addressed in accordance with the arrangement for providing services to UT System. If you have any questions, please contact your immediate supervisor or the UT System privacy officer. The minimum necessary rule applies when communicating with other entities and within UT System. Access within the covered entity to PHI, including use and/or disclosure to business associates, must be limited only to information the recipient needs to accomplish the intended purpose. Under the minimum necessary rule, our first goal is to use a limited data set if we need to provide PHI. A limited data set is PHI that has been stripped of most identifiers such as name, phone number, social security number, treating information, medical record number, and other identifiers. It may, however, include dates and certain address information such as city, state, and zip code. The minimum necessary rule would not apply to healthcare providers treating individuals, disclosures to the individual about his or her own health information, uses or disclosures authorized by the individual, disclosures to HHS for HIPAA enforcement purposes, uses or disclosures required by law. Part 3. Safeguarding PHI. The security rule establishes national standards that govern electronic transactions involving electronic protected health information, or ePHI, that is created, received, used, or maintained by a covered entity or business associate. The rule requires implementation of administrative, physical, and technical safeguards sufficient to ensure the confidentiality, integrity, and security of electronic protected health information. Security requirements for UT System PHI are addressed in the legal documents establishing the business associate relationship. Secure transmission of PHI is required. Ensure all electronically transmitted ePHI is sent in an encrypted format. Contact the UT System IT department or your IT department for assistance with encryption if necessary, and remember that information transmitted over the internet is not encrypted by default. If your services require faxing PHI, ensure the highest level of care by doing the following. Stay near the fax machine while transmitting or receiving. Never leave a document on the copier, fax, or scanner. Include a cover sheet with the fax indicating confidential information. Confirm with the recipient or sender that they are sending or receiving the document, and report any mishandlings to the privacy officer immediately. This should be a practice that has been pre-approved by UT System. If storing ePHI is allowed through your engagement, it must be done in accordance with UT System policy and the legal contract. ePHI must be stored in an encrypted manner as required by HIPAA and the legal engagement with UT System. HOP 4.1.1 requires all members of the workforce, contractors, volunteers, and others using UT System Administration information resources to review, sign, and comply with an acceptable use policy. UTS 165 and the AUP can be found at the link below. Computers should never be left unattended without logging off or locking the computer screen. Monitors should be placed such that the unauthorized individuals can Computers should never be left unattended without logging off or locking the computer screen. Monitors should be placed such that unauthorized individuals cannot view the PHI on the screen. Privacy monitor screens may be placed on the screen for enhanced protection. Lost or stolen laptops should be immediately reported to your supervisor and the UT System Administration IT department. Hard copies of PHI must not leave the UT System department where the PHI is located or where they are located within the contractor's organization. Hard copies of PHI must remain in a locked file cabinet or other secure space when not in use. Hard copies of PHI may not be left on a desk or out in the open for others to view. Once PHI is no longer needed, it should be rendered unreadable before disposal. Hard copy files should be shredded using secure shred bins. Conversations about PHI or including any components of PHI may not occur in open spaces. Despite our best efforts, sometimes inappropriate use or unauthorized access can occur, leading to a breach of PHI. When a breach occurs, we have a legal obligation to provide notification of the breach to the affected individual. The privacy officer is responsible for collecting information about possible HIPAA breaches and notifying the proper parties and affected individuals when a breach occurs. Contractors and third parties are required to comply with the terms of the legal contract with UT System and HIPAA in informing us about a suspected breach or security incident. Please work with your immediate supervisor if you suspect a breach or security incident. A breach has occurred when unsecured PHI has been acquired, accessed, used, or disclosed in violation of the privacy rule, and the disclosure compromises the security or the privacy of the PHI unless one of the three exceptions applies, which are discussed later in this course. Unsecured PHI is PHI that has not been rendered unusable, unreadable, or indecipherable through either of the following two methods, encryption and destruction. It may be written, electronic, or verbal. The notification requirement applies not only to unauthorized disclosures to outside parties, but also to intentional unauthorized access of PHI by people within our organization. If you suspect a HIPAA violation has occurred within your department or in an organization with which your organization is allowed to share UT System PHI, report this immediately to your immediate supervisor and the UT System Privacy Officer as required by your legal contract. The following risk factors are considered in determining whether a breach has occurred: the nature of the unauthorized recipient of the PHI, the nature and extent of the PHI involved, whether the PHI was actually acquired or viewed, and the extent to which the risk to the PHI has been mitigated. If a business associate has a breach affecting more than 500 people, it is the business associate's responsibility to notify UT System and HHS immediately. Notice must also be provided to prominent media outlets following the discovery of a breach. UT System Administration business associates are required to notify UT System Administration of any breach. After a breach is confirmed, the privacy officer, public relations representative, or other designated individual will have communications with the media regarding the breach. It is important that consistent analysis and communication surrounding a perceived breach occur to avoid inaccurately declaring an incident a breach if it is not. Not every impermissible access to PHI is considered a breach. As mentioned in a previous slide, not all access to PHI is considered a breach under HIPAA. Each incident must be reviewed on a case-by-case basis. Some exceptions to breach notification include unintentional and good faith access to PHI in the course of executing job duties. Should this occur in your department, communicate the accidental access with your supervisor and the privacy officer as soon as possible so that a determination may be made. Additionally, HIPAA requires documentation of the access even when a breach is not declared, so timing and details about this incident are important. Failure to comply with HIPAA may result in personal criminal penalties and fines up to $250,000. Incidents of noncompliance, including breaches, may result in fines of $50,000 per occurrence up to $1.5 million per year for each standard violated. Part 4. Individuals' rights of access to PHI. The privacy rule requires that individuals receive a notice of privacy practices from a covered entity. The notice of privacy practice must include the following: how the PHI will be used, the individual's rights under HIPAA, and the individual's rights to complain about potential HIPAA violations. A privacy notice does not give UT Systems the authority to release, share, or use PHI in a way that is not allowed by HIPAA. Direct providers, such as doctors and hospitals, have the more extensive privacy notices, which often include privacy notice acknowledgments. Health plans must provide a privacy notice, but need not obtain acknowledgment that the notice was received. UT Systems Office of Employee Benefits privacy notice can be found at the link on your screen. Individuals have the right to inspect, copy, and make changes to their medical records and PHI. The covered entity is required to tell individuals how to make such changes and allow them to inspect their records within 30 days of receiving a request from an individual to inspect. Business associates assist covered entities in meeting this obligation of access and amendment to PHI. Failure to assist can result in sanctions and penalties from the Department of Health and Human Services. Individuals also have the right to request an electronic copy of their records, request restrictions on how their PHI is used, shared, or disclosed for treatment, payment, and operations, receive an accounting of the disclosures of PHI made in the past 6 years. HIPAA allows a covered entity to disagree with requested restrictions by an individual, with certain exceptions. HIPAA allows for a parent or personal representative of a minor child to have the right of access to the minor's PHI. Certain exceptions apply to this general rule. State law permits a minor to obtain services without parental consent. Court or legal requirements authorize someone other than the parent to make treatment decisions for the minor, an emancipated minor, and in certain cases of abuse or neglect. When PHI is disclosed, the covered entity or business associate must account for all disclosures made for public health activities, judicial and administrative proceedings, law enforcement activities, government programs involving public benefits, and avoiding serious threat to health or safety, and others. Accounting of disclosures is not required when it is part of a limited data set, when it pertains to treatment, payment, or healthcare operation, when the individual's representative makes the request, when the individual's family members are present or during an emergency, and for national security or intelligence purposes. HIPAA prevents a covered entity or business associate from intimidating or retaliating against an individual for filing complaints with the Department of Health and Human Services. Requiring an individual to waive their rights under HIPAA as a condition to services or health plan coverage is also prohibited. Part 5, Texas Medical Records and Privacy Act. A state law passed in 2012, the Texas Medical Records Privacy Act provides stronger protections for individuals and their PHI. Any entity or individual that assembles, collects, evaluates, stores, or transmits PHI, comes into the possession of PHI, or is an employee, agent, or contractor of a person or entity described above. All covered entities and business associates must train employees regarding to PHI, adhere to additional patient rights, provide copies of health records to individuals within 15 business days of the written request, and not sell PHI. Penalties for violating state law range from $5,000 to $1.5 million per year. Part 6, Summary and Policy Acceptance. Complete policies related to HIPAA privacy and security for UT System may be found in the UT System Policy Library at the link on your screen. Specific policies are UTS 165, HOP 4.1.1, HOP 4.1.4, and HOP 4.1.5. At UT System Administration, we have a direct responsibility to ensure that our workforce, contractors, volunteers, and other third parties understand the importance of HIPAA, compliance with HIPAA, and the safe handling of PHI. As a contracted third party and business associate, completion of this training is required prior to accessing PHI. Acknowledgement of this training is required and can be found upon completion of this training. Please ensure that your UT System point of contact receives a copy of your attestation and training completion.